We are going to discuss about the remedies for the breach of contract. Welcome to Law with Me channel, and if you like this video, please do subscribe, like, and enjoy the video now. So, moving on, what are the remedies available for the breach of contracts? The first one is a suit for damages. The party who has undergone the breach of contract can ask for compensation for loss or damages that has been caused by the party who has breached the contract. Now, the remedy by the way of damages is the most common remedy available to the injured party. So, damages can be ordinary damages, it can be special damages, it can be exemplary damages or nominal damages, and even damages caused by delay or prefixed damages. So, any sort of damages will be covered under the remedies for the breach of contract. Any sort of breach of contract can be remedied. Okay. So, in the case Hadley versus Baxendale, there is a rule that has to be followed in this particular case for the suit for damages. It simply says that if there is any previous notice about the special damages in the contract, the injured party can only sue the other party for ordinary damages. It clearly says that if the person has added the previous notice about a special damage in the contract, in the written contract, only then the injured party can sue the other party for the other ordinary damages. Okay. So next, moving on, we have the suit for specific performances. So, when a compensation for the damage is not enough to cover the loss due to breach of contract, we can approach the court and ask the court to force them to perform as promised. So, sometimes what happens, you have gotten into your contract with another person or another party, and he fails to fulfill the contract of the terms of the contract. Then what happens? But he is ready to compensate for the failure that he is causing. But do you want that remedy or not is to be decided by you. So, if you don't want the damages, if you don't want to take the damages or the compensation for the breach of the contract that the other party has committed, you can approach the court and ask the court to force them to perform the contract as he has accepted or promised. So, this is one more remedy available. Next is the suit for quantum merit. This means it is suing for the amount of money that must be paid to the injured party for the work they had done till the breach of contract happened. Here what happens, the buyer rejects the consignment, for example. Then the person who has been ready with the consignment is left with a load of consignment and he doesn't know what to do with it. So then what happens, you can go to the court under this particular remedy and ask the other party who has breached the contract, the buyer who has breached the contract, to pay the amount of the consignment which is lying with the supplier. So this is one more remedy available if there is any breach of contract. Moving on, we have the liquidated damage and penalty. So, liquidated damage, what exactly is that? So, it is a reasonable estimate of likely loss in case of a breach which is mentioned in the contract before the breach. So, if there is any anticipation that there will be a liquidated damage, or if there is, if you can predict that this person, or in case if a party tries to breach the contract, then what happens, he can easily go to the court under this particular provision and ask the court to compensate for the damage that has been caused by the party. Okay. And here the amount that has to be given in compensation is priorly decided and it has been mentioned in the contract too. So you're not going to decide the amount in the court. But if there is a breach of contract, you're anticipating a breach of contract, or you want to take a prior, what do I say, prior precaution to stop the breach of contract, then what you can do is, in case if breach of contract happens, both of the parties can come to a conclusion and fix an amount. In case if breach happens, this particular amount has to be given to the other party as compensation, or as penalty, or as damages, and this is also allowed in the law. So, liquidated damage is a reasonable estimate. As I already mentioned, it is an estimate of the money of likely loss in case of a breach mentioned in a contract, which is already anticipated and entered into the contract before the breach itself. So, the penalty is an arbitrarily fixed amount of the money without estimating the likely loss in the breach. So, only the penalty is fixed by the court arbitrarily, and which is usually a high amount. And penalty also means that an arbitrarily fixed amount of money without estimating the likely loss in the case of the breach. So in penalty, what happens, even though the loss is only 10 crore rupees, I say, and if the loss is only 10 crore rupees, but there are many other things attached to the breach that the other party is undergoing. So the consequences of the breach of contract can be psychological, can be a loss of the goodwill. So considering all of this, penalties can be of high amount, irrespective of the loss, the amount of the loss incurred. The damages, the liquidated damages or the penalty will be of the high amount. Liquidated damages are nothing but anticipating the breach of contract and fixing an amount to be repaid to the other party when there's a breach of contract actually occurs, and you're already fixing the amount and mentioning it priorly as a precautionary method in the while entering the contract itself. But penalty is something that is that goes beyond the losses incurred. If the loss incurred is only 10 crore rupees, the person can be awarded 20 crore rupees penalty. Okay, the other party who is breaching the contract can be given or asked to pay penalty of 20 crore rupees. Why is that? As I already mentioned, breach of contract is just not about money and business, it's also about goodwill, maintaining the image in the society, maintaining the goodwill of the company, the image of the company, the brand, and also it can be psychological for many of the people who have gotten into the contracts. So to compensate for all of these things, it can be a hefty amount. Next, moving on, we have injunctions. An injunction is nothing but it's a court order that prohibits a party from committing a particular breach. So, for example, if one party is trying to breach the contract and if the other party gets to know about it, he can bring an injunction. He can go to the court of law and ask for an injunction telling that this party cannot breach the contract. So, this basically compels a party to take certain actions to rectify a breach. So, you cannot breach, but if you want to rectify where it is going on, if you want to fix it, then you can take some time. That's what the injunction says. Injunction is nothing but stopping one person from breaching the contract by the other person, okay, or the other party. One party who is in the contract stopping another party from stopping the breach of contract. Okay, so injunctions may be granted to maintain the status quo, to maintain the status as it is in the business, and to prevent the irreparable harm. So this is that if the consignment that is supposed to be coming tomorrow is not coming tomorrow, then you are compulsing the other person, the supplier, to rectify where it is going wrong and take some more time instead of breaching the contract itself, because this will be an irreparable damage to the company of the buyer. So to stop that, the buyer can actually bring an injunction and stop the seller party or selling party to break the contract that he has entered into. Okay, and this is to protect the non-breaching party's rights. Okay, so in the case of Gujarat Bottling Company Limited versus Coca-Cola Company 1995, the court issued an injunction to prevent the defendant from entering into a competing agreement. So what happened here was, here the court issued an injunction to prevent the defendant, who is the defendant here, it's the Coca-Cola company, from entering into a competing agreement. So Coca-Cola was entering into a competing agreement with someone else, and to stop that, the Gujarat Bottling Company Limited brought an injunction, so which would have breached its existing contract with the plaintiff. So they both were in a contract, that is the Gujarat Bottling Company Limited was in a contract with the Coca-Cola, and Coca-Cola was trying to make a competing agreement with another company, and to stop that, this Gujarat Bottling Company Limited brought an injunction from the court and stopped the agreement, the competing agreement that was entered, that was supposed to be entered by the Coca-Cola company with an other company. So here with this we'll end this class, and if you like the video, please do like, subscribe, and give us a thumbs up. Thank you for watching this.